Ordinary Firearms NFA Weapons Update and Enforcement Trends. Some of these we've hit already, and I'm just going to walk through the list with you again to make sure that I've not left anything untouched as we move on to more substantive material. The first is the narrowing the line for FFLs versus collecting or building as a hobby firearms, or building collections or liquidating collections. The line is narrowing. The more and more a person is liquidating or building a collection, or the more and more they're selling firearms without going through an FFL, and it appears they're making money on it, and some of the jury instructions around the country become diluted and say some money. They're not saying all money, they're just saying make some money, as opposed to the principal objective of livelihood or gain. That line's getting narrower and narrower if you're advising FFLs. And frankly, FFLs are opposed, I think, primarily and principally to those people that are skirting the line from doing so, because the profit margin on guns at retail is a very low profit margin. I'm going to hit this in passing because I believe it's been pretty well exhausted and by ATF and is no longer an issue, but if you technically read the Gun Control Act, you could read it to talk about guns that affect interstate commerce, and someone that had read that well on both the East Coast and West Coast had come up with the notion of taking 80% lower, which is 80% finished, a block of metal that's a lower for, let's say, an AR-15 or military parlance at M16, renting an individual a CNC machine. They push the button that loads the program that mills the lower, and because the position was that's never going to be an interstate commerce, it's not required to be serialized, marked, or otherwise, I advise the client that's never going to withstand the intent or scrutiny of ATF, and they're going to eventually be closed down. That's in fact what ATF has done. Within a day or two of a letter I received from ATF, an opinion letter, indicating that was illegal, those shops or institutions were closed down. My suspicion is there are thousands or hundreds of thousands of firearms floating around from these build parties that are functional lowers, or the part of a firearm that's required to be and identified with the firearm, that if you're a lawyer and you face that, my belief is those are contraband and would have to be surrendered to law enforcement as contraband. There's not a real clear way to wind up making that and putting it in a lawful stream of commerce, because for an individual to do it, they would probably need a manufacturer's license. So recognize, like those marked magazines for the assault weapons ban, you may run across one of those weapons. In California, I know the build parties occurred, and on the East Coast, if you do, I believe those weapons are contraband and have no way to be lawfully brought within the scope of the lawful possession by anyone. I would indicate to you there may not be a clear way to not implicate a client by surrendering these firearms if you are faced with that situation as a lawyer, but ATF and most state and federal and local law enforcement officers are very much like mindset with lawyers about following the laws, and I think on the whole would rather a firearm be off the street and surrendered as contraband than to arrest and prosecute the person behind it. That's obviously situational. It's based on the location you're in and the relationship that you have with those entities, but that's what I've used successfully in state and federal cases, which is to, you should be a very cautious person, be perceived that way by law enforcement, and build those bridges so that where there isn't a direct answer to a question, you can have a rapport with law enforcement that by asking it doesn't presuppose that you're involved with it or you have a client involved with it. Can I surrender this to you as contraband? And there are ATF forms for that. We've talked about the build parties. I want to talk about legalization of suppressors. An area that's really getting a lot of attention is states now are getting away from the notion that sound suppressors are inherently evil And even though they're required to pay a tax and they're NFA controlled items, there are about 1 million suppressors out there in the marketplace, and the trend is growing for hunting, different calibers. So suppressors are going to more and more be an issue that are going to be dealt with by attorneys. They make a lot of sense from the standpoint you're not creating noise that's disturbing in a hunting environment. You're not creating noise that's going to ultimately make the person have a hearing loss impairment. But suppressors are a new hot trend in the marketplace that are NFA weapons, or NFA controlled items, I should say, that are out there and being sought after, and more competition and more manufacture in the marketplace. FFL and SOT, which allows an FFL to sell NFA weapons compliance. I'm going to use another term we haven't talked about. It's referred to almost exclusively by an acronym, which is A&D. That stands for acquisitions and dispositions. What do you receive that's a Title I or Title II weapon or firearm as an FFL or SOT, and what do you send out? ATF periodically on the compliance side, no more than once a year, will come to a FFL or SOT holder and do an audit. For those of you who are dealing with ATF audits and compliance audits, the position is not substantial compliance. The position of filling out the 4473 form and keeping an accurate log of acquisitions, what you receive in weapons and what you send out, is deemed an absolute requirement of law enforcement, and the licensee that's not following that subjects themselves to revocation of the license up to and including criminal prosecution. It's a zero tolerance policy by ATF when they do compliance checks. It's very important to impress that upon your clients, whether they're manufacturers or whether they're just an FFL mom and pop shop. ATF expects every 4473 form to be correct, expects the acquisition and disposition book to be correct, and expects the inventory to match up accordingly. So that is a seminar in and of itself, but I throw those out if you're involved in that arena and your FFL is calling and saying, I'm having a compliance check and I have some problems. They have a big problem. And if they get a warning letter, they get an actual meeting with ATF, that won't happen repetitively over years and years. They will have their license revoked, so their livelihood and ability to earn for themselves is in serious jeopardy if they're not following the ATF requirements for being an FFL holder or an SOT. So what I would encourage you to do is a couple of things. One, argue for and make the case to your client that going to computerized A&D book as opposed to paper makes sense. Secondly, do a double check. And the double check process and clearing up and avoiding errors is very clearly set forth on the ATF website in some of their informational materials, and I would encourage lawyers to look at that as a baseline. The third piece that I will mention, it was an add-on thought, is there's no substitute as a lawyer if you're facing advising either a manufacturer or a small gun shop about compliance issues for a site survey. It may seem wasteful to the individual that's paying you to come and do a site survey, but every time I've done it without fail, I can walk in and say, you know what? That gun right there is problematic for this reason. This process is problematic for this reason. This kind of interaction or this kind of merchandise is problematic for this reason, both under state and under federal law. It's money well spent by the client as opposed to waiting until the compliance check is over and they receive a warning letter, because again, there won't be too many of those before their license is revoked or they're in fact criminally charged. I've talked about the gun show loophole a bit, and I've fleshed out for you, because being counsel for a large gun show, I get that question. How can you allow an individual to build or buy and sell and build and liquidate a collection as counsel for a gun show? I don't. Gun shows are one of the most controlled and regulated, at least well-run gun shows, events that exist on the planet. Police officers from local, state, and federal agencies attend. The individuals that are violating that rule are setting themselves up for almost certain prosecution. Having said that, if you're a lawyer on any side of this argument, it's a very thorny one to deal with. There's a federal right, again, we talked about, to liquidate a collection, to build a collection, or for a hobby to buy and sell without having a federal firearms license. So the question becomes, depending on the side of the fence you're on, who are you going to treat unequally? Are you going to tell the gun show representative or the promoter they can't have a gun show because it's arguably protected freedom of assembly and freedom of speech? Or are you going to tell grandpa selling a gun off coming in the gun show he can't do it because he might be a dealer? All of these involve competing legal interests, and there's no clear answer except to use common sense. But the gun show loophole as being the cause of guns pouring out in the street is a legal fallacy when you apply all the laws to all the groups that are involved with gun shows. Are there bad gun show promoters and events? I'm sure there are. No different than there's bad in everything else in life, but that is a symptom. It's not getting to the root cause, and I only throw that out there because that's received an awful lot of press attention lately, and I've talked about it and distilled it, and that is, I, as a lawyer living in a free, great country, as I'm sure you all subscribe to, whatever your position is on firearms, am not going to discriminate or advise a client to discriminate against someone for any reason whatsoever if I can avoid it. And the gun show loophole predisposes discriminating against some group, whether it's not having the gun show, not allowing the private buyer or seller or collector there, or some way or another discriminating against the individuals that want to come and attend the gun show as a guest. So think about that if that's an area that you address as a lawyer, which is gun shows, and how you want to respond to that. And if there is a solution, and is it a root cause, or are we dealing with a symptom? I don't know the answer, but I can at least throw out that that's one of the hot topics right now. We've already talked about inaccurate denial for incomplete state and federal background checks and some of that and what it entails to correct it. So I'm not going to spend any time on that topic, but refer you back to our prior discussion. I will talk about the 4473 form because lawyers unfortunately make this mistake more often than I would believe they would, which is having someone question you about a 4473 form, a client, a gun shop, a manufacturer. You can play this question out in a lot of different ways, but I'll give you a recent classic example. I had an attorney advise the client, no, you can check no on the 4473 form. You're not under indictment, because an indictment is what the federal government uses when you're criminally charged, a grand jury indictment. We don't use that in this state. We use informations, or we use a charging document. It's not an indictment, so you can answer no. As it turned out, the owners of this particular gun shop happened to be frequented by a lot of law enforcement and owned in part by law enforcement, and they knew the individual or suspected completing the 4473 form had an indictment pending against him, and ultimately it resulted in serious questionable ethical questions for the attorney, and the potential that the client could be charged with perjury for inaccurately completing his 4473 form, even though the ultimate transfer of the firearm didn't happen. So when you're signing under penalty of perjury or you're advising a client, be very careful that what you think is common sense or a no-brainer is in fact not laden with some complexity under federal law or state law you're not thinking about. For instance, I routinely consult with law firms around the country, sometimes mega law firms on ATF issues or compliance issues, and one in particular had the FFL, and this makes sense. You want the documents in front of you. You're a lawyer. You live and breathe by the written word. What's the law say? Okay, client, I'm an hour away. Bring me your forms and bring me your A&D book, and I'll copy them, and then we'll sort through this problem you have. Those materials have to stay on site with the gun licensed retailer and SOT or the manufacturer and cannot leave that facility. Could ATF choose to take them or allow them to be removed? The answer is probably yes, and I'm sure there's some practice, protocol, or obscure provision of the CFR I don't know about, but that attorney created a large risk for his or her client had ATF called up and said, I need you to trace a stolen firearm, or had ATF walked in and said, we're doing some follow-up to our compliance check, let us see this or that. And in reality, those records aren't there. They're with the law firm. And this is not a law firm that's sloppy. This is a great law firm. It's just this whole area is laden with risk, and it's something that I can't stress enough to help you identify that what seems like common sense might not be.